if you're able to file for a bankruptcy and you have to do a Chapter 13, and all of your disposable income in the Chapter 13 has to go to your creditors, that's 5 years out of your life. The bankruptcy laws changed. We got BAPCPA, and the big purpose of BAPCPA was to reduce the perceived abuse of the middle class who potentially wasn't repaying debts or didn't want to repay their debts.
I firmly believe, and have for the last 20 years, that all they did was create an industry of people who provide those classes, and that it serves no function for the bankruptcy filer whatsoever other than to allow them to file the bankruptcy and get out of it. I think there are some hidden costs too. When you have someone who has significant debt, they are miserable and stressed, and those things lead to illness and missed work and kind of being a jerk when you're driving a car because you're stressed out.
What are your thoughts on that? What do you see as possible changes that they might try to enact if they would change the bankruptcy laws moving forward? Hello, this is attorney Jamie Miller, and I'm excited to welcome you to another edition of the Miller Law Chronicles podcast. I hope everyone is doing well today. I have my special partner in podcasting, and Deborah Stencel. How are you today, Deborah?
I'm doing well. How are you, sir?
I am good. I'm a little bit sad. It's the morning after this just terrible plane crash in Washington, D.C. As a person, my daughter lives in Washington and my brother lives there too. And, you know, we're in and out of Reagan Airport a couple times a year. And you can really kind of get a sense of kind of the location and the Potomac and how scary it is with so much traffic going into this small airport. Such a loss.
Do you know, it brought up for me one of my earliest memories, which was that plane that crashed in the Potomac in January, I'm going to say 81. Do you remember this? I think it was a wind shear problem. And what I remember very clearly is the survivors in the cold water. And this always makes me cry. The man who kept passing the rope to other passengers so that they could be rescued first.
Right.
And he ended up drowning.
Yeah. Yeah. And it was wind shear or it was a de-icing problem because they talked about that crash last night. It hit the bridge. And then said last night, I mean, because the plane and the helicopter, when they collided, you know, were 300 feet up in the air and went into the water. You know, the odds of someone surviving was very slim. But then you take into consideration the water temperature. That if someone would have survived, hypothermia would set in after 15 minutes, and it's just a tragedy. And I heard this morning that over the weekend, the U.S. figure skating championships were in Wichita, and there were some people on the team that were flying back to D.C. So it'll be sad to hear, perhaps, you know, people from that team and people in general that were lost.
Yeah.
On that, not to start it off on such a sad note, but, you know, we'll get to the bottom of it, and hopefully lessons can be learned to make airline safety an even bigger priority than it is. And it seems like, you know, at least the officials, the president came on this morning and started with the blame game a little bit. I think it's premature for that. There's a lot of time and investigation that has to go on. So hopefully they'll get to the bottom of it and that we'll learn something from it.
Right. That's going to take a while.
Yes. I wanted to kind of talk a little bit before we get to our bankruptcy topic of the day, which is going to be the 20th anniversary. Is it really 20 years?
Yes.
Of BAPCPA as we know it. It's the what does it stand for? The Bankruptcy
Abuse Prevention and Consumer Protection
Act of 2005. And that was passed in October of 2005. I think we all remember the date, October 17th. right?
Right.
So October 17th of 2025 will be the 20-year anniversary. I remember that vividly. And tell me, what are your memories about that time?
So it was crazy and hectic. Everyone, I mean, it was sort of a national trend to try to file your bankruptcy before the law came to being on October 17th, which I believe was a Monday of 2005, because the change in the law imposed all these additional burdens on the person filing a bankruptcy. The classes that are required to file were new, and they were intended to steer people from chapter 7 into chapter 13 or deter them from filing bankruptcy altogether. I firmly believe, and have for the last 20 years, that they did was create an industry of people who provide those classes, and that it serves no function for the bankruptcy filer whatsoever other than to allow them to file the bankruptcy and get out of it. But that's just me. So at the time in 2005, everybody wanted to get their bankruptcy filed. It was a very, very busy year.
Right. Even to take it back further, if you remember, there was a presidential election in November of 2004,
Right.
and I think that was the Bush Gore. Was that the hanging Chad?
No, that was 2000.
Okay. But who did Bush run against in 2004?
Okay, you are mean. That would be Kerry, right?
Okay, we'll go with that.
Yes, it was John Kerry.
Right. You're right. So he ran against John Kerry. And I remember one of the big campaign conversations, which was kind of surprising, was BAP CPA was you know, changing the bankruptcy code. And I remember during that time period being so focused on the change in the potential laws that we kind of knew that if Bush won, that the laws were going to change, and if Kerry won, they weren't. And so it gave us even more interest in that race.
Right, right, right.
And so then it took some time, and then finally they got the votes. And in fact, I remember being at a Bucks game way back then, probably, winter of 24 going into 25, 2005, and going to talk to Herb Cole, who was a senator at that time. And in my own little way, trying to rally him against, the possible change in the bankruptcy code. Well, anyway, the bankruptcy laws changed. We got BAPCPA, and the big purpose of BAPCPA was to reduce the perceived abuse of the middle class who potentially, wasn't repaying debts or didn't want to repay their debts, which I think was kind of a myth. I know we're bankruptcy lawyers, but way back when I didn't see a lot of abuse. I mean, the perception that people wanted to file bankruptcy has always been a myth. People don't want to do it. It's always situational, whether it's medical bills or credit card bills. People used it as a means to get out of debt, prevent garnishments, that type of thing. So, and then they wanted to make it harder for individuals with higher incomes to qualify for Chapter 7. Talk about that for a minute, what that looked like.
Yeah, so before the change, to qualify for a 7, your budget had to be reasonably in the negative. So if your income, it didn't matter what your income was, if your expenses exceeded your monthly income, you essentially qualified for Chapter 7. So in theory, someone who makes $120,000 a year with no children, if his or her expenses or their expenses were big enough, they would qualify. But the fact of the matter is, that person isn't going to unless they have no medical insurance and have a chronic illness, right? Because they're not going to let you get away with a $1,200 car payment. They're not going to let you get away with. I remember having this argument with a client once that paying for $250 a month for pool maintenance was not a reasonable expense and not really fair in a Chapter 7, right? But, if you have child support to pay that's really high, or special schooling costs or anything like that, someone with higher income could have qualified for a 7. But
Right.
that's still the case.
Right. And they introduced something called the means test. And the means test is an income test that sets a level of income that you need to be under in order to qualify for a Chapter 7. And if you're above that income level, we do some, mathematical gymnastics, and it'll either tell you you qualify to do a Chapter 7 or you have to do a Chapter 13 repayment plan.
Right.
And, it's pushing people into Chapter 13s that prior to BAPCPA, you know, wouldn't necessarily have to do that.
I have always believed that the people it pushed into a 13 that weren't in a 7 were less, the numbers came more from the changes to who can file a Chapter 7 and when. Before 2005, you could file a Chapter 7 every 6 years. After 2005, the number changed to 8 years. There were some changes to Chapter 13 filings and so on and so forth. And so that particular thing pushed more people into a 13 than the income test, in my unstudied opinion. But if you have those special expenses, you can still claim them now. I think the law change just made bankruptcy more work, more expensive, and a little scarier for some people who have a hard time handling paperwork and stress, which is unfortunate.
Right. And as you mentioned and alluded to a little bit ago, there was a race to file bankruptcies before October, what was the date? October 17th
Right.
of 2005. So we were all inundated, all of us who were practicing bankruptcy. And, everyone who needed to file bankruptcy filed bankruptcy before that date. And then all of a sudden, it's October 18th and the floodgates were closed and bankruptcy essentially died for, a year, 18 months after
Mm-hmm.
that. It was a time period where there was a lot of fear on the part of the lawyers trying to figure out what the new world was going to look like,
Right.
going to seminars, trying to figure out the means test and, some of the insanity of the law. But when push comes to shove, what really dropped the bankruptcy filings was the fact that the floodgates opened before October,
Mm-hmm.
not necessarily the law change. And as we learned, once people started going through the cycle of needing to file again, those people that filed had to, and the numbers, started to increase again. I don't think since 2005 we've been at the number of filings that we had pre BAPCPA, like in the Eastern District of Wisconsin. Off the top of my head, we normally get about 11,000 bankruptcies a year.
Right.
I think that number's down about 8,000 or 7,000 now. I don't know exactly, but it has been about a 20 to 25% drop. So if the drop in bankruptcy has been the goal, then there has been some drop that way. But at the same time, go ahead.
Well, I'm just going to say, don't forget the 2 or 3 major events in the last 20 years that also impacted bankruptcy filings. First, there was the mortgage crash in 2008 and the Great Recession, I guess is what we're calling it. And during those periods, people were deterred from filing bankruptcy because some didn't have the income to pay for a lawyer and because they were waiting for things to get even worse. So they were holding it in their back pocket. And then, of course, for 3.5 years during COVID, people weren't being garnished or mortgage foreclosed or sued. So they had no impetus to file then either. So that's a good significant chunk of that time after 2005 where numbers were lower, but it's not because of BAPCPA solely. It's these other economic factors that happened. I pray that we get back to normal because it will mean that the economy is working and nothing else terrible is happening to us.
Right. And that's an interesting point too, because as the economy goes, so does bankruptcy. But even when we have a phenomenal economy, we still need that parachute relief
Absolutely.
of bankruptcy. So it's nice that it's still there. You and I were talking about before we got on today about kind of BAPCPA, BAPCPA, whatever we want to call it, as being a failure. Tell me a little bit about your thoughts on that. Do you think it was a failure? Has it found success? What are your thoughts on that?
I think that the means test, while I think the goals of some of it were not met, but things have changed that probably have utility. For instance, the means test, while it made bankruptcy more expensive and scares people away and all the things we already mentioned, there's a uniformity of application instilled there so that somebody in Southern California is being treated the same way as someone in Iowa with adjustments for local numbers. And versus just the considered opinion of the official in charge of the case to say, oh, you qualify for a 7. So that's kind of nice. I think it allows social scientists to pull numbers and analyze who's filing what, and that has value. I have no patience for the classes, so I have a hard time finding a positive there. But, well, the rules about refiling are possibly acceptable. There's always, for the honest debtor, there's always a bankruptcy option if she needs it, right? If you're in trouble, there's probably something we can do to help you. So that's a good thing.
Right. And, you've done many more Chapter 13s over the course of the last years than I have. And if the goal has been for kind of the middle class or the higher income class to pay back their debts through a Chapter 13 versus wiping it out, has that goal really been reached? And my thoughts on it, and looking at all the Chapter 13 plans that we file, most of the plans are paying creditors 1%, 10%, 15%. And you have to wonder the expense, the lawyer's fees, the trustees' fees, the administrative fees. Are the creditors really better off administering a 1% plan or getting paid on a 1% plan or a 5% plan versus just being able to close their books and have a Chapter 7 discharge the debt?
I think that's a really good point. I see an awful lot of 0% plan cases, and they're justifiably 0% plans. It's fair for that person to do that. But her creditors are then left in limbo for 3 to 5 years to make sure that the thing gets ended. If the creditor misses the claim filing deadline, even if our client wins the lottery, the creditor's not going to get any money. Common credit card creditors get these notices and do nothing with them. They throw them in the garbage, as far as I can tell. They don't respond, they don't file claims, which ends up benefiting my client. So that's great. But I don't know what it's doing for these little guy creditors. I think car creditors won in the changes. They get paid first often in bankruptcies, and that's a big win for car creditors and a loss for us and everybody else.
Right. And one of the things that concerns me about bankruptcy that I've always thought being a benefit to the economy is if someone has $100,000 in medical bills, they're doing everything they can to pay off those medical bills. Perhaps their wages are getting garnished. The magic of Chapter 7 for that person, because if someone's in debt like that, and you have millions of people in debt in this country, if they're stuck in debt and it's perpetual, they're not really being economically valuable to our economy
Right.
because they're not able to purchase. They're not able to, buy things for their families. They're not able to get loans. And so their participation in the economy is stuck. And I've always thought that the ability of someone, even with a higher income, so, if you're making 60,000 a year or $100,000 a year and you had a heart attack, God forbid, and you have $500,000 in debt in medical bills and you can't file bankruptcy, you are stuck there forever. And then if you're able to file for a bankruptcy and you have to do a Chapter 13, and all of your disposable income in the Chapter 13 has to go to your creditors, that's 5 years out of your life. That's 60 months that you're kind of frozen from, you can buying a new car, which you can, which is a challenge, or buying a new house, which can be a challenge in the chapter 13, spending money, investing money. It
Hmm.
just it just doesn't make sense in the global scheme of things.
I agree with that. And I think there are some hidden costs too. When you have someone who has significant debt, they are miserable and stressed, and those things lead to illness and missed work and kind of being a jerk when you're driving a car because you're stressed out. So you call somebody a name and honk your horn, and then you make somebody else I mean, the ripples are huge. And if you can alleviate that stress for folks quicker, they might be on this planet a little longer and contributing to society in other ways. So people get sick from their debt, and it
Right.
just drags. I mean, that's why, we don't have bankruptcy because we want to give people a free ride. Bankruptcy has been a thing since before the Bible because it helps the economy, it helps society. It's not about giving somebody a handout at all.
Right, right. Yeah. And it's, this whole myth about people defrauding the system and that bankruptcy, those that file bankruptcy are taking advantage, is an absolute myth. In all my years of the thousands of bankruptcies that I've personally been involved in, yes, I've had people that are gaming the system, but it's very, very, very small. And to
Mhm.
punish the whole for the bad actions of the few bad actors just seems unfortunate. And if BAPCPA's goal was to reduce filings, well, they reached that goal, but it's been at a significant cost to middle class families who are experiencing genuine economic crisis, and we've kind of left them hanging there. If you're poor, if your income is in the poverty range or below median income, there's help there. But if you find yourself in that middle range, you're going to be effectively punished and not going to be able to get that fresh start that the bankruptcy laws once promised.
Not to beat my favorite dead horse, which is student loans, but that's another failure. Student loans in Chapter 13 are treated differently from every other debt. Because they're classified the same way as a credit card, they may get no money in the bankruptcy. But because they are specifically excluded from discharge, when a person tries to use a Chapter 13 to solve their problem and takes the 5 years that they're allowed, when they leave, they may have gotten rid of everything else, but now their student loans are not only 5 years older, but they're 5 years worth of interest bigger. And there's no way in the code to treat them any differently. You can't elevate them above the way credit cards are being treated. You can't exclude them from the bankruptcy in most cases. And that is really tough. Now, federal student loans have special programs that mitigate that somewhat, but private loans do not. And there are plenty of heartbreaking stories of people leaving the bankruptcy and walking into, oh my goodness, what happened to my private loans?
Yes. Yeah, because it's like, oh, you can do a Chapter 13 and you don't have to worry about paying your student loans during that time period, but you're just continuing to dig a big hole because interest continues to climb on those student loan debts. And, we've done prior student loan podcasts. We've
Sure.
talked about, dischargeability of student loans and these new DOJ initiatives to get rid of student loans. So if you're a Miller Law Chronicle podcast listener, kind of go back on YouTube or Spotify or Apple Podcasts, and you'll find that because there's some great content on discharging student loans. So, there's been talk moving forward, but about additional bankruptcy reform. What do you know? What are your thoughts on that? What do you see as possible changes that they might try to enact if they would change the bankruptcy laws moving forward?
Well, the thing I just mentioned, so we won't go back to that. There might be further tweaks on serial filers. I have heard there might be. I think that the means test makes a lot of folks happy, so that Form 122 is here to stay. It has value, I think, for fairness across the board. So there's that. I would like to see some guidance on some universal guidance on the fees that professionals are allowed to charge, not only the debtor's attorney, but the trustees attorneys, the creditors attorneys. There's some unfairness in the way it's handled now. Well, those are my top ones right now.
Right. The bankruptcy laws were set up at some point to help people obtain relief on their own. And the complexities that came with BAPCPA made getting that relief impossible if you want to do it on your own. It's the bankruptcy process is so complex. The documents that you need to submit to the courts and to the trustee, that doing it on your own is something that's really challenging. And if there's a way to modify the bankruptcy laws to allow people that can't afford to hire a lawyer to file bankruptcy on their own and find success, I think that would be a decent reform.
It's a
Um,
good idea.
yeah, I can't tell you the number of people that come to us that need our help, that tried to file bankruptcy on their own and just found roadblock after roadblock, and it ends up costing them so much more money in the end. It always makes sense to hire a lawyer, but the bankruptcy process should be easy for those that can't afford to hire a lawyer, and I like to see that. I'd like to see that change. And I think one of the other protections that's coming in, that needs to come in, is preventing non lawyers from
Oh,
filing
sure.
bankruptcies for people. That's been an issue here in Milwaukee with non attorney bankruptcy petition preparers taking advantage of people by filing bad bankruptcy cases, which only causes more problems. And what you had, looks like you had another thought also.
Oh, I just want to go back to the classes. It used to be they were $7, $8 and an hour of your time. And so even if there wasn't a ton of value in the classes, not too bad. But now I'm seeing fees of $50 and it takes 3 hours. And my clients still aren't learning anything. They're not coming away with life skills that will make it better. And they're not being deterred from filing the bankruptcy. So what's the point? I would like to see some change on those classes, some more regulation, moderation of the fees, and possibly just, turning it into one class, not one in and one out.
Right. Yeah, and at the time BAPS CPA was getting enacted, in the credit education courses, you have to do one before you file, and then you have to do another one after your case is filed. That was a compromise, if you remember. And the bankruptcy bar, the lawyers that were helping to write the bankruptcy laws for Congress, was telling Congress, this is, you don't need this. This
Right.
isn't going to deter people from filing. But it was a final compromise that the legislators thought, hey, we need to keep this in because we are going to educate people out of filing bankruptcy. And I don't know one client that's really benefited from those debtor education courses. And it's a cost, either, like you said, 25 before you file, 25 after you file, that's just making these debtor education class owners profitable, make money. And it's just an added cost that's not needed.
Mm-hmm.
Thank you. BAPCPA has been frustrating for all of us. It's just made the process so much more complicated for everybody in the system. I remember, when we used to practice bankruptcy prior to 2005, we had all of just honest people that needed to file. It was kind of a court of equity, a court of fairness, and that whole thing's changed. It is an adversarial process, and you have to fight tooth and nail and go through 100 different steps to get your bankruptcy discharge that maybe many people deserve.
Yeah, that's true.
Gosh, we complained a lot on this podcast.
We said some positive things, right? There was
Yeah,
some good stuff in there.
yeah. Well, I appreciate your time today. Did you have fun?
I did have fun. I really enjoyed talking about that.
Do you have any exciting plans for the weekend?
Oh, I have a couple of shows and a new group I've joined that's going to do Shakespeare in a bar.
Love that. Did you see Saturday Night, the movie about the making of the first episode of Saturday Night Live?
Not yet.
It is on Netflix. It's called Saturday Night,
Yes.
and it covers just the hour before they do the first episode of Saturday Night. And if you want to do something really fun, watch the movie Saturday Night and then rewatch the first episode of Saturday Night Live from 1975.
What a great suggestion. That's
So,
a weekend project.
do you remember who were the guests were on the first Saturday
Oh,
night?
on the first one? No, I don't. I mean, I'm going to guess George Carlin or Buck Henry.
No, George Carlin was perfect. So, George Carlin was the guest host. He was the host. Janice Ian and Billy Preston were the musical
No
guests.
kidding.
Andy Kaufman did his comedy act. But it's hard to find the first episode. I found it on Prime.
Oh,
You have to pay $1.99 to get it. And I watched it. It was very entertaining.
so when that was on TV, I was too young to be allowed to watch it. So my brother and I snuck downstairs with a blanket and held it over our heads so that the TV light wouldn't go up the stairs to watch Saturday Night Live every week.
Classic.
Yeah.
Yeah, I definitely recommend that. Something for you and Matt to do this weekend.
Check.
Good luck. It's a 50-degree day here in Wisconsin. So, if you can get out of the basement for a minute and enjoy a somewhat sunny day, I would urge you to do so.
Thank you. Take care. Have a great weekend.
Okay, thank you so much. I appreciate your time.